Welcome back. I'm Uday Pratap Singh. You're joining us on NewsX. Our big focus this hour, the Delhi High Court on Friday has upheld the central government's decision to temporarily restrict access to instant messaging platform Telegram ahead of the NEET undergraduate 2026 re-examination, holding that the measures adopted by the government were proportionate and narrowly tailored to address concerns over examination malpractice. Remember, in a special telecast, NewsX had brought the Telegram files for you with screenshots and pictures showing how the NEET question paper was circulated on Telegram. Sakshar Duggal, AI governance law expert, is with us live. Varun Singh, managing partner at Foresight Law Offices, also joins us live. Mohit Yadav, cyber expert, is joining us live. Piyush Bhardwaj, cyber law expert, is also on the broadcast with us. Let me make a start with you first. Sakshar Duggal, what do you make of the order that the court gave today, and do you believe this is a step in the right direction for propriety, for transparency, for avoiding any kind of malpractices ahead of this retest?
Well, there are a lot of deliberations that right to equality has not been adhered to, but I beg to differ. I completely support the judgment with the High Court has come up, because at the end of the day, the message is loud and clear. A poor compliance history, no government in India will tolerate that, because if you see Telegram, there has been a poor compliance history, number one. Number two, it's just it's the minimum takedown that can take place. The takedown is still 22nd of June, and till 30th June that edit feature has been disabled. If you ask me, definitely it's the right step in the right direction, because today's Telegram, but tomorrow no intermediary out there will not take anything for a ride, because at the end of the day, India is now moving forward with a strong compliance structure altogether.
Absolutely. Sakshar, stay with us. Varun Singh is also joining us live. Varun, for the legal perspective, how do you react to the hearing and how it panned out in the court, of course, yesterday and today with the judgment out? Do you believe that this, at the end of the day, has been a very balanced verdict, upholding what the centre believes is a prudent step ahead of this retest examination? They've given proof and evidence that many instances of the leakage of the paper happened through the Telegram app. Do you believe then that this was an expected verdict, what we've seen today?
Well, I think on law as well as propriety, and both require demand and answer. So in terms of law, I think what Sakshar mentioned about poor compliance, I think the DPDP Act, which is the new Data Privacy Act, is putting out significant number of regulations which could be applicable to any significant data fiduciary, and Telegram would be one. So, and unfortunately, the regulation which governs significant data fiduciary is not there as on date. So if you were to come out with a real compliance, reasonable security measures which are applicable to any such app like, say, Telegram, WhatsApp, and so on and so forth, this issue will not arise so much so. Secondly, I think from the aspect of propriety, I mean, look at it this way. In one sense, we are saying that the government will not be able to ensure that leakage will happen. But if the leakage is happening and a third-party agency is allowing it to be circulated, then the third party should be shut down for its activity. I mean, you have to get your own house in order before looking at elsewhere. From whatever I read in the judgment, also the allegation is that there could be fake question papers which could be circulated. Now, if the question paper is fake, then anyway it has no credence. And if the question paper is actually real, then the leakage is actually happening within the system, no? So one should take corrective measures to fix what is there in the house in order rather than shooting elsewhere. I think that would be a prudent step from examination perspective. And if for regulating any intermediary, I think the best and the most proper step is to come out with the regulations which all these significant data fiduciaries are anyway awaiting, because the act needs to be applicable, the rules need to be put in 1st of May 2027, but yet the significant data fiduciary additional burden has not been clarified as of date. So if that is to happen, then everybody has to fall in order and has to comply with everything that is required of them.
Let me also get you in here, Mohit Yadav. Mohit, because the fact is that there were many instances given, and we also at NewsX had put out yesterday the Telegram files, instances of the leaks, how the paper was being circulated, groups as well that had been circulated, to fast track and forward this leaked paper. So clearly there was a lot of locus standi, and that was backed up by evidence presented by the court and the centre and the centre's lawyers yesterday. Do you believe then that it was very difficult for the lawyers of Telegram to try and argue otherwise?
So I'll put it this way, that Telegram is a source right now that has been very actively in a lot of scammers on Telegram, a lot of things related to privacy and all sort of different copyright content. We can find it on Telegram. All the dark web stuffs are there on Telegram. So ultimately, Telegram is a source where all those things are happening at very large scale. So government has to take this kind of action, because if we are not in a situation to take such action, definitely the lot of scams will be there. A lot of a situation will be worsened in coming days. But this ban, I think, like this is something which is not permanent. I think, which is not a good foolproof solution to it, because right now also a lot of people are using Telegram, using VPN and all those.
Okay, so you're saying
like
this is a stopgap.
servers.
This is a stopgap solution for now. It needs to be strengthened further. So Piyush Bhardwaj, do you welcome this verdict today by the High Court? Do you believe perhaps a longer ban is needed on this particular app?
Well, definitely. I would say that in every way it's a welcoming step, that although the High Court has refused to lift the ban, noting that the government concerns about the exam integrity were serious and was a warranted action. The court also acknowledged the broad public view that impacted millions of users, but emphasized that preventing cheating in national exams was a pressing public interest. The government also relied on the provisions and the greater interpretation of Section 69A qua the IT Act, citing the public order and exam security. And more so, although pressing arguments were made by the Council for the Telegram, and therefore the court has also emphasized the question of the proportionality test, whereby the public interest and exam integrity will have to be balanced against the digital rights of a mass consumer base. More than 150 million users are purported to be using the app. So it actually questioned that whether blocking an entire platform was proportionate to stopping cheating, or the ban was justified in order for public provisions. But till the time that we see at the cornerstone that the exams are on the helm of affairs until the 22nd, I mean the purported dates given in the affidavit of the center, the blanket ban has to be applicable, considering that the exams and the product of the examination is considered something to be of a very interesting value when it comes to the sovereignty of the country. So any kind of reassessment or any kind of technicalities, whether as to how complex this technical and legal issue is standing before the court firsthand, will only have to be dealt when these NEET examinations are dealt, which are at the far side. The court had also observed the view that although the Council for the Telegram has made very broad averments that the officer has only parroted the views of the government and there is no real application of mine. The court has also made an observation that the government is clearly responsible and justified in taking these extreme steps, considering there had been past instances and of such kind of display of information where the platform has failed to comply such kind of implications like edit feature and bot usages. So in my personal opinion, considering the gravity of situation, the center and the court's judgment is very welcoming step.
Okay. Let me in fact quickly now also rope back in Sakshar Duggal, because Sakshar Duggal, the fact is that there have been instances, evidence that we also at NewsX have put out showing how these Telegram leaks happened, the forwarding that happened through this app, the chats as well. There have also been now instances that the center's lawyers yesterday cited are talking about security risks as well through this app and potential anti-national conversations and terror recruitment as well, and activities which also happen through this app. Do you believe then that possibly a longer ban is needed? Sakshar Duggal? I think we've lost Sakshar. Why don't you take that, Mohit Yadav? Is a possible longer ban needed, or do you believe that won't be in the right spirit?
See, I will say that I have used Telegram a lot, but truly, when you say like, is there anything which you have found very valuable in Telegram? Yes, you can say that all the pirated movies you can download from Telegram. All sort of betting apps are there, betting people, betting on those channels. So I don't think like the chat because the platform itself is not able to comply with all those things which is being given by the government, so they have to comply because that's the platform. It's their duty to stop all those activities. If they are not able to stop all those activities, definitely government has to take any kind of step. So at this point of time, I feel like that yes, Telegram should be banned because people who are actually not aware about all those privacy and all those concepts, they are also visiting Telegram. They're also downloading contents from there. The pirated softwares are being downloaded. The mobiles are getting hacked. So a lot of things are happening. A lot of scammers are there. You see all different kind of scams happening on Telegram. Why not we should ban Telegram? Because ultimately Telegram, most of the other channels, other providers do support the government, but Telegram as a whole organization does not support organizations by giving the IP addresses of the people who are doing such things.
Yeah. On the other hand, Varun, the app Telegram said that they felt they were being singled out for this, and they said it's unfair as actually students also benefit from this app and the activities that happen on the app. What did you make of that argument, and why do you believe the court did not, pay heed to that?
Well, I think, and it's an interesting point. And in fact, if you think of it this way, with the advancement of technology, every app, every intermediary, every technology is being used for good and bad purposes both. The idea is, as rightly been debated everywhere, it is to ensure that there should be enough regulations in a country to ensure that this misuse does not take place. And if at all there is any misuse, then that should be caught the moment the government seeks any information from that very intermediary pertaining to that very illegal activity, whether it is against the national interest or whether it is against any issue regarding an examination. Now, those powers the government anyway has under the new act. And if the new act requires a further step, which is to find a way to regulate all these intermediaries, including Telegram, including WhatsApp, because I'm sure you when you covered the last time around the leak issue arose in WhatsApp last time around. So all these intermediaries have to be regulated and they have to follow a certain standard, which not only India, but most countries are wanting it to apply to any such large technological company. But looking at this issue in isolation, my firm belief is that right now, the aspect of NEET examination falling apart and blaming it on just one intermediary may not be appropriate in case there was a debate pertaining to the fact that if at all the leak has to happen, the leak has to happen internally first. If nobody gets if nobody outside the authority gets access to a leaked question paper, then where is the question of it being circulated illegally through any other app? If that debate does not take place first and we look for actions to stop, because if you look actions, we will find on every app.
Okay.
And in every form of intermediary. That debate needs to happen first and then this debate. And according to me, they can happen simultaneously.
Khushbu Jain is also with us now. Khushbu Jain is also joining the broadcast now. Cyber law expert Khushbu Jain. The ban upheld. Do you believe this is a good order by the High Court? What do you make of what they've said in their order, in their judgment? And do you believe this will lead, perhaps, hopefully, to a foolproof retest?
See, if you see this, with this matter, we need to understand the facts. The facts are very important over here. This act
done by the government was not a random or an act done on a whims and fancies to ban a messaging app total, taking away rights of the entire citizens of the country. No, if you'll see, there is a time-bound, exam-linked order which was passed after concrete inputs from national testing agencies that said that the cheating rackets were using specific Telegram channels, and in particular, the feature of edit and delete to circulate these leaked papers and answer keys as well. Now what they do is they send it and then they wipe it or rewrite the entire trail. So the traceability part was completely eliminated. So we do have laws in place, we do have mechanisms in place, but because of this feature, the traceability becomes not negligible, but it absolutely negates the entire purpose that how do you reach the person. So the number one was the leak part, the second the using of the Telegram channel for that, the second was the edit and the delete feature. Now after this, if you'll see, invoking of section 69A of the IT Act, I think we need to understand that this power of section 69A of the IT Act was a power given by the Parliament, upheld by the Supreme Court in plethora of judgments, which says that this power under section 69A can only be used through a structured process in which they involve a designated officer. There is an interministerial committee, there has to be a recorded reason, and there has to be a periodic review. There is also an element of emergency in that, where they can issue an order in an emergency situation where they don't go through this process. But even in the emergency, they have to table the entire report within 48 hours, and that can be rejected or can be accepted. Now, if you see, this entire process was taken care. So this was not an order issued on a whims and fancies of a government getting up one fine day that, oh, let's just block them. This was a formally authorized, reason-based, time-limited blocking direction targeted at one platform, looking into one high-risk feature, and also looking around the single
And backed up with evidence. Let me reiterate, backed up with evidence.
Absolutely. Now, coming to the second part, which was discussed in the court, was the proportionality part of it. That the Shreya single judgment also, if you look into it, the courts have been very wary that these are the rights of the citizen. When you curtail, when you block anything, either a URL or an application, you are practically curtailing the rights of the citizens guaranteed under the Constitution. That's where if government has to act upon these, there has to be a proportionality test. Now, with that proportionality test, if you look into from the constitutional standpoint, you will see that the aim was clear, it was legitimate, it was to protect the integrity of a national medical entrance exam, also a preventing of a large-scale fraud and a public disorder. Now, if you'll see this, the direct nexus, because cheating networks were actually operating on Telegram, exploiting the delete and the edit version of it. Our government did request Telegram to act upon it. They said that please stop this feature of edit and delete, please stop. They were continuously in to and fro of a discussion with Telegram. If not happening, practically we can't expect a company which is for their profit motive to look into the citizen, to look into the security, to look into the emergency situations of our country. It is our government who has to act upon it, and I think the government has acted, and we should all commend government to act upon it. Had they not act upon it, we should have questioned that despite having laws in place, despite having power in place, why are you in the hands of these technology platforms and not acting upon it, where rights of the citizens, rights of those students, and also the trust of people, trust of those students in these exams will be completely wiped out. So practically this will be mockery to our education system into it. And if you'll see, in the real time, nothing else was possible for them. So that proportionality test was also met. So the power, rightly so, the proportionality test, yes. Whether can be done for the future government that this becomes an arbitrary power? No, this is not an arbitrary power for the government, because the section itself provides for entire procedure to be followed. So I think it's not a question that we should be asking whether rights of the people, or whether government was right in doing so, whether a platform or the messaging apps, whether it is right for taking away their entire access, or their existence in the country for whatever the time-bound manner, the restrictions into it. I don't think so. That's the question. The question when it comes to government, it is us as a citizen who should be protected. It can be against anybody. And if the same thing would have happened, imagine in the physical world, you would have expected the government to do so.
Okay. Well, we are almost out of time. I'm just going to quickly leave the last word to you on whether you believe this is something, Piyush, that is likely to be extended post this retest, Or do you believe that's again another chapter that can be appealed again in the court? If the government does decide to extend the ban, would it be a prudent move? And what do you believe then the legal ramifications would be if an appeal were mooted of such a move?
Well, definitely, it cannot act as a complete blanket order for time indefinite. It will, for all citizens to come, and as a legal precedent also, it will have to be a balancing act. Considering the intensity and the seriousness of the situation at hand, a blanket ban is nothing more than something that was urgently required. But curtailing people's rights and our large user base, we as India is one of the largest user bases of internet per se, all the applications. So I do not see it as something that can go for long. Definitely, it is going to be an appealable order. But considering the ramifications of 22nd June and a national level medical test, going by the timeline of 22nd June, I don't see any relief coming from Telegram till that point in time.
All right. Well, let's leave it at that. My thanks to all of our guests for joining us with your perspectives and viewpoints. Let's move on now to some breaking news coming in this hour. After DMK cut ties with the Congress and refused to attend